Tonight, clash of the arms of government as High Court judge throws out Speaker of Parliament certificate granting permission to MP for Boko Central to be absent from court in case in which he's charged with several criminal offences. Well, tonight, members of Parliament are set to challenge the High Court's position at the Supreme Court.
The exclusive jurisdiction for the interpretation of the Constitution is vested in the Supreme Court and not the High Court. We intend to challenge and table before the Supreme Court of Ghana.
This is Top Story with Evans Mensah.
And Top Story is always brought to you by Bond Savings and Loans. Your success, our passion. Also brought to you by Gasem Cement, the nation builder. Vodafone, the future is exciting, ready, and Nationwide Medical Health Insurance, your healthcare family. Well, two arms of government, the legislature and the judiciary, have today clashed, both flexing their muzzles over who has the final say to dictate an MP's availability to answer for criminal charges filed against them. At the center of the arms of government tussle, call it so, is MP for Boko Central, Mahama Yariga, who is facing criminal prosecution for alleged tax evasion, amongst others, at the High Court. Now, there is a lot to get through for you tonight. We're going to cover this from both Parliament and from the courts. My colleagues, Joseph Opoku-Gapo and Joseph Akable, are in the studio with me. They've been covering this all day today. Joseph, let me start with you. Two separate cases came before Akable, I mean. Two separate cases came before the High Court today, filed by the special prosecutor against Mahama Yariga. What are these?
So the first relates to a procurement of ambulance for his constituency. The special prosecutor has some concerns about due process not being followed. The other relates to the purchase of an official vehicle for him. You recall we had dealt extensively with that particular one relating to a loan facility that was granted MPs through Societe Generale, and the special prosecutor making a point that he had got the money, but he had used it for a different purpose, not buying a vehicle for official use and not paying the duties required of that, and also charges relating to dealing with in Forex without the appropriate authority to do so.
Okay, so what happened when these cases were called? The first one was called and the second one. What happened?
So the first case relating to the ambulance, there are actually 6 other persons that are charged together with the MP. So when that case was called, all 6 of them stood up. The MP, who is the 7th accused person, was absent. And at that point...
Was he the only accused person absent?
Yes.
Okay.
For that case, he was the only accused person absent. And at that point, the judge asked why all the accused persons are not present. Then Gordon Tamaklo, who is Mama Yariga's lawyer, stood up and told the court that his client is unavailable. So at that moment, the judge asked that all the lawyers approached the bench. They stood up, they went. We don't know what interaction took place, but when they returned, she announced that it's a criminal proceedings and it cannot continue without the accused person being present. And so she's giving them time. They should all go and meet and come and tell her at what exact time all of them can be present.
Today.
She stated emphatically that this must be today and not any other day. So she gave them some time to go and discuss amongst themselves and come back to tell her when all of them, that is the accused persons, all of them will be present for the case to progress.
They came back and said what?
They came back and they told her that 1 p.m.
Okay. So this is where it gets interesting. At 1 p.m. And so the court went on recess, I guess.
Yes.
Went on a break.
They went on a break.
Awaiting
then subsequently took other cases. Then
whilst they waited for the 1 p.m.
Yes.
In that period, something else was happening in Parliament on the same matter. Joseph Gakpo was in Parliament on that. During that break, what was happening on the floor?
So around that time that Ayariga was being sought for in court, well, he was on the floor of Parliament, and this was around 10:20 thereabouts. It was actually the first item that the House dealt with after all the discussions around votes and
apparently this has come to the attention before the House started.
So there was what they call a pre-sitting meeting, at which leadership decides the agenda for the day. So we got to know later that at that pre-sitting meeting chaired by the Speaker himself, Mr. Ayariga had been invited to the meeting, and he had drawn the speaker's attention to his concerns that he was being invited to court at a time that he was supposed to be in Parliament to do his responsibilities as an MP. So on the floor, the opportunity was given to him to make his case, and he raised a number of issues. He drew attention to various aspects of the Constitution, including Article 112, where he says it grants some immunity to MPs when they are supposed to get their jobs done, but that he had received a summons from the Special Prosecutor to show up in court on a Tuesday morning when he's also supposed to be in Parliament representing the people of Boku Central. And so he was requesting of the Speaker that the Speaker gives a ruling as to whether, per the dictates of the law and the provisions in the Constitution relating to immunity for members of Parliament, it is allowed for an MP to abandon his duties and show up in court. But that wasn't the only argument he made. He also drew attention to what he says was a situation where the special prosecutor had actually not served him personally with the writ of summons in connection with this case. And it was one thing he kept emphasizing, that they had tried serving him through Parliament, and Parliament had written a letter, and he quoted that letter and read it on the floor of the House. That Parliament had written a reply to the special prosecutor, drawing the special prosecutor's attention that the effort to serve him as an MP through Parliament at a time that the House is on recess was out of place.
And that violates the constitutional provision that grants him the privileges and immunity.
Which is actually the point that had repeatedly been made, that before you can do any such thing, you need to get to the Speaker and get the necessary approval in order to get an MP to court. So he was emphasizing that the special prosecutor's attention had been drawn to the error that they had committed, but they hadn't rectified that and has still gone ahead and showed up in court this morning and were calling for him to be made to appear. And he actually described the effort as dangerous if the immunity that MPs enjoy in the course of their duties is actually played with as he claimed the special prosecutor was trying to do.
So then what happens? I mean, because after this time, the court was insisting, I'm sure this time his lawyers were calling him and saying 1 p.m. is approaching, you need to show up in court. What did he do?
So he made that reference to the issues on the floor of Parliament, because at a point in time, for almost an hour after he made a statement, the Speaker more like interrogated him, and were asking a lot more questions and were getting more details from him. And he made reference to what was happening in court, that his lawyers, who he had instructed to show up in court today on his behalf, had updated him that the court had asked them that, well, by hook or crook, he needs to show up in court.
So what do you do? Parliament had to take a break at some point over this as well.
Yes, so there were contributions from both the majority and the minority, and then it resulted in a long discussion. After that, the Speaker indicated he was taking a 30-minute break, so that then he would come back and rule on what the way forward should be. And in the course of that, all the MPs were in the chamber. Discussions were ongoing. Mahama Yariga was holding various meetings with a number of the MPs in Parliament, the Majority Leader Alban Bagbin, the Second Deputy, the First Deputy Jose Usu, and all of that was ongoing. And instead of the 30 minutes we were expecting, the break ended up lasting for well about 2 hours plus.
Did he get any certificate then?
So this is what happened. Around 12:30, by then the House was on break, the Speaker was in his office. So Mahama Yariga actually left the chamber and stepped out with a number of the MPs and went to the Speaker's office. This was around 12:30. And then, from what we gathered subsequently, the said certificate which the Speaker himself had made reference to when he heard Ayariga's complaint, and he said that it was being written and it was in draft, was actually given to him. This was around 12:40.
To take it to the court.
To take it to the court.
And this certificate, just to clarify, is mentioned in the Constitution, that the certificate will give a certificate that sort of will show to the court that in fact he is actually attending to parliamentary business, and so should be excused from attending to the court.
Exactly the case. And so this was actually handed over to him, and subsequently, even well after he had left with the certificate
to go to the court,
to go to the court, is when eventually the Speaker recalled the House at
and gave a ruling. Okay, this is in essence what the Speaker's ruling was, and during this time Ayaga was not in the chamber.
No, by then he had left. To attend a number of the members of Parliament.
So,
James Agaga,
this is the Speaker's ruling. The Speaker's ruling in essence was that the court's attempt to demand that he attends today, whilst the case was pending, was a breach of the Constitution, was a breach of his constitutional rights and privileges. Listen to what the Speaker of Parliament said to the court in this matter.
Also, as has been the practice, the court noted the constitutional injunction that has been that have been minded to schedule court sittings to accommodate the legislative calendar so as to ensure the smooth administration of the judicial, legislative, or executive governance of the state. It is my prayer that any agency desirous of serving civil and criminal processes on the Speaker or any member or clerk to Parliament remains mindful of what Article 117 says and the gloss that time-tested practices have conferred upon it. Honourable members, to do this in any other way not only breaches Article 117 of the 1992 Constitution, but potential offence Article 122 of the Constitution as well. Honourable Ayariga has agreed to appear before the court by 1 p.m. is accordingly released today. I trust that reasonable arrangements will be made to try him, as he is surely not above the law, but in a manner which will enable him to represent the good people of Boku Central. In the meantime, as he is presumed innocent also by operation of law until proven guilty, I trust the court will also act accordingly.
Okay, so that is the Speaker of Parliament's verdict. And when the Speaker rules, it carries all the full force of that particular arm of government, the legislature. Okay, so in essence, the wording was also captured in the certificate that Ayariga then shows to the court. Joseph Blay. So Ayariga shows up in court with the certificate from the Speaker saying...
In fact, he walked into the courtroom 10 minutes to the 1 p.m. deadline.
Okay, so he actually was on time.
Yes. In fact, the court was on recess then waiting for 1 p.m. before it resumes. So at 1 p.m. when it resumed, Mama Yaga was present, same with the other MPs that accompanied him.
A lot of them.
A lot of them, yes. The minority leader, James Agauga, Okujeto Ablakwa, amongst others. And when the case was called, Mama Yaga's lawyer was the first to speak, and he informed the court that he was trying to explain why Mama Yaga had failed to show up in the morning. He was explaining that, saying that it's not because he didn't disrespect the court, but he was trying to secure a certificate from the Speaker of Parliament, which they've attached to the court documents now. So at that moment, the judge asked to have a look at the certificate. Then when she looked at it, she said she needed some few minutes to write her decision.
Let me quickly read what the constitutional provision says about the certificate so people will understand it. This is Article 118. It says, one, neither...
So you can actually start from the 117 because in the letter it cites the 117.
Because the speaker made reference to 117. Let me start from there. It says, civil or criminal processes coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member or the clerk to Parliament while he is on his way to, attending at, or returning from any proceedings of Parliament. Now, 118 says, 1. Neither this Speaker, nor a member of, nor the clerk to Parliament shall be compelled, while attending Parliament, to appear as a witness in any court or place out of Parliament. And here's a mention of the certificate, which he brought to the court. 2. The certificate of the Speaker that a member or the clerk is attending the proceedings of Parliament is conclusive evidence of attendance at Parliament. In other words, once he produces it, the court should know he's attending. You cannot ask him to appear at all court. This is what he brought to the...
Yes, so the judge actually read the letter from the Speaker and made reference to the certificate and made reference to this particular provision. The judge actually read the two provisions that you made reference to. Then when she finished, she makes the point that this does not respectfully apply because... One, he said Mahama Yaga is not a witness to the court. And secondly, he is an accused person who has been charged and duly served, in the words of the judge, duly served. And so he's supposed to show up anytime the court needs him.
Fundamentally, this judge, what's her name, by the way?
Justice Efia Sewa Butwe.
She rejected the Speaker's certificate.
Yes, she says it does not apply. In this particular matter,
because
he's not a witness, and secondly, it's not the case that they are attempting to serve him with something. He says he's an accused person who has been duly charged and served. In which case he has to be present whenever he's needed.
But there's something else she says. She says that she's the only person who dictates when Ayaga comes to court or not.
In fact, that was
not the Speaker.
That was when the entire proceedings had ended and they were just about to leave. She kept asking them whether anyone has any clarification they want to seek from her. Then she says, for the sake of emphasis, in the first case, there are 7 accused persons, each have his own lawyer. He said, together with the special prosecutor's office, making 8 lawyers. So he says, no one can dictate to me when I fix my date. And I'm telling you that when I fix a date, no one can absent himself. You all have to be present.
Whether you are
no
an
excuse
MP or not, I don't care.
No excuse. You have to be
come.
present.
Now, so there were reactions, and as you can imagine, a lot of his colleague MPs, including the minority leader, accompanied him.
Yes.
They spoke to you. In fact, listen to the minority leader, Harun Adrisu, just on the steps of the High Court, making the point that they are going to challenge this judge's ruling at the Supreme Court.
It is trivializing the matter if you limit it to the Honorable Mahama Yarga. We are talking about Parliament as an institution, and I pray that the 2 arms of government, Parliament and the judiciary, does not get to a collision course. The lady presiding, respected lady presiding, have had to make a pronouncement on Article 1182, as was conveyed to her by Right Honorable Speaker Professor Mike Okwe. It is important to note that the exclusive jurisdiction for the interpretation of the Constitution is vested in the Supreme Court and not the High Court. And indeed, it should be read together. 1182 and 1181 and 2, and more importantly, 122 and 117 of the 1992 Constitution. Article 117 deals with matters of service of criminal and civil proceedings to a member of Parliament. We are law-abiding, we are in court, we will respect due process, but our privileges and immunity, we will seek clarification. We intend to challenge and table before the Supreme Court of Ghana. We would invoke the exclusive jurisdiction of interpretation on Article 118 and 117 and 122 accordingly. I do not think that the presiding judge had the clothes to interpret the Constitution as I understand the 1992 Constitution. To Honorable Mahama Yarga, don't personalize it to his person. We're just seeking clarification as to the tied end appearing in Parliament and exercising a representative role. He's an elected member of Parliament of Boko. He represents us at equals. So when he's serving at the equals level, what happens? When you need him and he has it. Respect the Constitution and Article 19 again, presumption of innocence and his right to a fair trial. So if you presume that an elected member of Parliament is presumptively innocent, that is it. A right guaranteed him under the 1992 Constitution. So we are not saying that we will not or he would not appear before trial, but allow him to work as an elected representative of Parliament whilst he respects due process and the rule of law. That is what we are seeking clarification on and nothing more. I thank you.
So that is the minority leader. Shortly, we'll hear from the Attorney General's office. We'll be speaking to the Deputy Attorney General, who says that the Speaker of Parliament's ruling on this matter is also something that they cannot ignore, and so indicating to us that henceforth, even when the AG wants to prosecute a case involving an MP, they would have to do it at times on Monday, for example, when MPs do not sit. I'm grateful to say that we just been joined on the telephone line right now by a member of Mahama Yarga's legal team. He's also a member of Parliament. He is also the ranking on the Defence and Interior Committee, James Agaga. Thank you for your time here on Top Story.
Thank you, Evans.
But the judge and the High Court, she's right, is she not? I mean, she references Article 118, where the Speaker also referenced in his certificate, and says Mahama Yarga is not a witness in this matter. Mahama Yarga has been duly charged and served in this matter, and so this doesn't apply.
Well, Evans, thank you very much. My initial reaction is that when constitutional issues have been raised and brought before a judge, the judge is under an obligation to read the Constitution as a whole. Because remember that the provisions of the Constitution are interlinked, they are interrelated in so many ways. And so in appropriate cases, for you to be able to make sense out of one particular provision of the Constitution, you must read them together with others. And so on this occasion, the Speaker's certificate actually made specific reference to Article 118. And 118, even if you read the short title to that provision, it's very clear. It talks about witness summons. So that article relates to cases where a member of parliament or the speaker of parliament or the clerk of parliament is summoned to appear as a witness. And so in that respect, the judge was right that Honorable Ayariga was not before the court as a witness, and therefore the speaker's certificate did not apply. But Evans, in my humble view, the judge ought to have gone beyond Article 118, because the argument of Ayariga, I guess, was not lost on the judge at all. Ayariga clearly was claiming immunity from processes of the court, not just its summons for him to appear as a witness. He was simply just protesting against the fact that whilst attending upon Parliament, he has immunity not to be dragged before a court of law simultaneously. And so the judge, in my humble view, ought to have read Article 117 and even 122 together and take into account its cumulative effect. In so doing, if she felt that there was need for her to make a referral to the Supreme Court, which is the court with the exclusive jurisdiction to properly interpret those articles and tell us what their cumulative effect is, the judge ought to have done that. But in this case, she also confined herself to just Article 118 and arrived at the conclusion that Honorable Ayariga was answerable to her court and that the trial needed to continue. In any case...
Just a minute. You raised Article 122. That article talks about contempt of Parliament.
Absolutely.
Are you suggesting that the actions of the special prosecutor or the court was in contempt of Parliament?
That could be in contempt, because the provision is very clear that any act which obstructs Parliament from performing its duties, or a member of Parliament from performing his or her duties, is in contempt of Parliament. The wording is very clear.
So in this case, help me understand, which of these two institutions was in the contempt, in your view?
Evans, if you ask me, I would say, first of all, as at the time Honorable Ayariga responded to the court's directive that he reports at 1 p.m., Honorable Ayariga had not been served with any summons. In fact, Honorable Ayariga, as at the time he voluntarily attended upon the court at 1 p.m., had not been served. He was only served upon arrival in court. And that is the point we're talking about.
So the special prosecutor's office was in contempt of the court?
When a member of Parliament is attending upon Parliament, or is on his way from Parliament or returning from Parliament, you cannot serve him with a court summons. This position is captured under the Constitution.
So the special prosecutor's office was in contempt?
Evans, I cannot make that definitive pronouncement. If the special prosecutor or anybody whatsoever who attempts to obstruct Parliament from performing its duty, or a member from performing his parliamentary duties, that person is deemed to be in contempt of Parliament.
So what I hear you say...
I can make the definitive pronouncement if the appropriate motion is moved and whoever is involved in such conduct is referred by the Speaker to the Privileges Committee. The Privileges Committee has a preserve to make appropriate recommendations.
Will you move? Will you move?
Or otherwise, for the committal or otherwise of that person.
Will you move?
Make conclusive comments on the question.
Will you move?
Because it entails an elaborate procedure.
Will you move that motion?
Well, I am counsel in the matter. I act upon the instructions of my client. I don't have those instructions for now. At the right time, if appropriate instructions are issued, we'll follow it through.
Just stay on the line for me briefly. I just been joined by private legal practitioner Kofi Abochi with thoughts on this very fascinating legal debate. Mr. Abochi, where do you stand on this very intriguing question?
If I understand the general tenor of things, you're speaking about Mr. Ayariga having been invited to appear before court while he's in the middle of parliamentary business. There is an immunity which covers a member of parliament while he's performing parliamentary business, and therefore, ordinarily, such a person shall not be the subject of parliamentary proceedings. Now, I know that the Constitution actually restricts itself to the service of process or arrest or being invited to perform the duties of juror or being invited to testify as witness. So these are the circumstances in which there's a restriction, and therefore ordinarily there's no mention of a person appearing as a party in this matter, a criminal party, a party to a criminal proceedings in court. Now, I would say that the Constitution actually contemplates this as well, because in my own understanding, the Constitution is focused on preventing situations where members of Parliament or Parliament itself is obstructed in the performance of its constitutional duty. Now, the purpose for this is to ensure that Parliament, being a representative body, and in this case, a member of Parliament being a representative, is not obstructed in performing that representative function. That representative function is very important, and as sanctimonious as it is, you do not expect that you undermine that through a court process. So the member of Parliament is not immune from criminal proceedings. It's important for this to be clear. However, he is immune from being compelled at the moment when he's in the business of parliamentary work to attend to court proceedings. And so there could be an adjournment. There could be other flexible considerations in respect of which the member of Parliament can be allowed to attend to the judicial obligation later in time without having to do it at that point in time. And as I indicated, the purpose is to avoid undermining the representative function of the member of Parliament. Otherwise, we'll have a member of Parliament in Accra who is trying to defend himself, say, criminally, and then in the process, he's not able to perform a parliamentary duty, and therefore his representative responsibility as a member of Parliament for a particular constituency is undermined in the process.
Mr. Abochi, so the follow-up question then is, the actions of the High Court today, did that amount to undermining his work as a member of Parliament because he was on the floor today?
It's a very interesting area because it's been mentioned about in respect of being contempt of Parliament. Now, contempt has to do with not only the act itself, but also the intention behind the act. Being a criminal, as the lawyers would call it, a quasi-criminal offense, the intention behind the act is invariably looked at. Now, it's a balancing thing we have here, and one would expect ordinarily that there is some cooperation or collaboration between the two institutions. This is not the first time Parliament and the judiciary have come on some kind of collision course in which you have the judiciary pulling in one direction and Parliament pulling in the other. Fortunately, we've had a harmonious coordination over the years, and one will expect that to move on in that direction. As I indicated, I do not think that ordinarily on the face of it, this would amount to contempt at the intent level, i.e. the intent is not to obstruct the parliamentary business overall and the parliamentary duty or responsibility of the MP. I do not think that is the intent. I think the intent is to promote the administration of justice, and from the end of Parliament, the intent is to ensure that parliamentary business is maximized and that a member of Parliament on the floor is not inhibited in the performance of his work. So I do not think it will amount to contempt of Parliament, but I do think that where this is pushed to a certain degree or a certain level, especially where the court has been apprised of all the facts and informed sufficiently that when this MP is pushed to the brink and he eventually has to forego his parliamentary business and come to court at that particular time, that will undermine his work. It may, at a certain point in time, amount to contempt if clearly it is established that the intent is to obstruct parliamentary business, so that together with the act, when put together, you may have an element of criminality. And as I said, at the moment we are not there, but hopefully, I do hope we don't get there. But when pushed to the brink, it may just amount to contempt, especially once the intention becomes clear.
Was the judge of the High Court right, within her rights, to reject the Speaker's certificate, having ruled on the matter quite conclusively in the legislature?
It is the province of the court to determine what the law is. So whenever there's a contest involving the interpretation of the law, it is the courts that ultimately have the final say. And so the judge was totally in her right to go and make an assessment of the speaker's letter, first of all, to determine the question of legal validity. Second of all, to determine the issues of law that may have been raised in there. I do think, and I say this with the greatest respect, but I do think that it was a bit wrong for the Speaker of Parliament to have made an assessment of what the law is. It is not the business of the Speaker of Parliament to determine what the law is. It is not part of parliamentary business. It is not part of the Speaker's business. Parliament's job is to make the law. And so the Speaker haven't gone the length of actually, asserted and purportedly defined the parameters of the law and even quoted aspects of the Constitution and tried drawing the judge's attention to those things was a bit close to dabbling in the business not only of the judiciary but even of lawyers, which is exactly not the province of the Speaker. And I know the Speaker is a lawyer, but the parameters and the contours of responsibility are clearly defined, and parliamentary business is separate from judicial business. So I think that the Speaker shouldn't have done that. Now, having done that, I think the court was totally in its right to have made an assessment of that and made a judicial determination of the validity of the Speaker's position. But as I indicated, a public tension clearly played out the way it's playing out, as it were. It's problematic for all the institutions involved. Parliament and the judiciary are two of the most respected three branches that we have in Ghana. I mean, two of the three main branches in Ghana. And therefore, the expectation is it should be coordination, it should be collaboration, and not tension. And so, in the circumstances, my expectation is the issue will be resolved moving forward properly, even though clearly the interest and the right of all the parties involved cannot be compromised because we are a country of laws and not of men. But as I indicated, I hope it is resolved without the tension and without the public display as it's playing out.
Mr. Gaga.
Yes, hello.
Yes, you had the position there. What's your own take on that? And whilst at it, didn't your client sort of surrender his rights when he decided to attend on the court, if indeed he believes that his rights under the Constitution has been violated? He could have just sent somebody to Senate and disregarded the court.
I don't think so. What the Honorable Mahama Ayariga did was to show respect to the court. Remember that even before he decided to submit himself to the court voluntarily, he had not been served with any summons. The summons was actually only served on him after he had arrived in court. So that is the point that needs to be taken note of. But having said that, Evans, the opportunity to canvass the arguments predicated on the Article 117 and even 122 would be taken. I mean, in the light of the Speaker's ruling, we're definitely going to have to file supplementary affidavits and canvass those arguments before the judge, with the hope that if she comes to the conclusion that the issues requires some interpretation, then I would expect her to do the proper thing by making the referral to the Supreme Court for the issue of immunity for members of Parliament to be determined. I mean, once and for all, when we are attending upon the business of Parliament, these matters need to be settled once and for all.
I'm grateful that you joined us. James Agaga there is a member of Mahama Yariga's legal team. He's also the ranking of the Defense and Interior Committee. Earlier, you had Kofi Abochi, who's also a private legal practitioner. Still ahead here on Newsnight.
Shraj takes up NPP chairman Freddie Blaise challenge as it files contempt charges against him, praying the court to sentence him to jail term after he called their bluff yesterday. And also the indemnity clause has emboldened certain characters to abuse their offices and profit massively. Former President Jerry John Rawlings demands an immediate review of such clauses, saying the Constitution was written by men.
There are many constitutional clauses that do not serve our interest.